Okay, we're almost ready to start here, but I see a couple of people trickling in, and we'll give them a minute before we actually officially launch this webinar around GDPR.
So a couple of quick housekeeping items while we are waiting for everybody to trickle in. If on the chat window, if you can put your name and which city you're from, that would be awesome, just to get everybody situated in. So there's a chat window on your Zoom meeting. If you can just type in your name and which city you're from. So and make sure that the broadcast message goes out to everybody so everybody can understand where people are coming from. And we'll get started in about
30 seconds.
30 seconds, yeah, awesome.
Okay, so I'll get started here. I'll start with an introduction about myself first. My name is Anup Surendran. I head up product and engineering at QuestionPro. On the side, I do these small projects like GDPR, right, Viv? And it's our way to get in front in terms of compliance and regulations. Another background around about me is I've been with the compliance and security landscape for the last 4 to 5 years before joining QuestionPro, and I'm happy to bring that expertise back into this company. Go ahead, Vivek.
Thank you, guys. Hey, this is Vivek here. I'm one of the founders here at QuestionPro. Been a developer all my life, then somehow randomly became a CEO one day, I guess. So I don't have the kind of compliance experience that Anup has, but I have the hacking experience needed to get a project off the ground. Before we get started, I do have a funny story about Anup and me. A lot of people don't know this, but Anup and I were actually roommates about 20 years ago in Russia. So we studied, both of us left India in 1995, 96, I think. Mm-hmm. And both of us were we actually were literally roommates in the dorms in Russia for about a couple of years before I moved to the States, and Anup moved to Canada, and so on and so forth. So, and when we obviously we kind of lost track of each other, and then about 15 years later we got connected, and then Anup has been a part and parcel of the QuestionPro journey for the last 5 years. Thank you, Anup.
It's been fun, yeah. I mean, he has never stopped hacking, and I think that mindset itself is good enough for us to know what can possibly go wrong with GDPR. And it's going to be, we're going to be extremely upfront here, and he's going to tell us 4 things which we have to do to avoid jail time. I mean, he's not that he has gone through jail, but he has, like he said, he has experience hacking. I will be walking through the ethos and definition of GDPR. And I'll push this back to the solutioning piece of it for Vivek to walk us through. And towards the end, we have a Q&A session.
All right, let's get started. All right. So the GDPR has 99 articles and 200 pages. And I'll tell you what, I've read most of it. In fact, I've read more than most other people. Let's put it that way. And then what we've done is really, like any regulation that comes along, nobody's probably got the time to read through every single piece of it. And regulations take time to kind of formulate themselves. And what we believe, there are like 4 kind of important elements. If you want to, walk away from this webinar, we are like 4 minutes into the webinar. These are the 4 things you need to care about. If you care about these 4 things, very likely, I mean, obviously, jail time is tongue-in-cheek, but really, the fines is where people are getting nervous about. The fines are something like 10% of revenue, or it's actually a revenue-based fine. It's not a flat fee. It's not a $25 flat fee for making a mistake. It's a percentage of your revenue. So I'm gonna really go through what it means. So informed consent. This article basically states that users need to know what is being collected and how will it be used. So effectively, you can put a legalese. You cannot really put a legalese terms of service with a checkbox and hide behind it. So you really need to explain 2 key elements, right? What is being collected and how will it be used?
Good. And the next thing here is DPA with vendors. If you are a decent sized business, you will have vendors. And the second most important element for GDPR is data processing agreements. And they're called DPAs for short, but they effectively form a chain of responsibility for vendors and partners. So a good example is we deal with our own vendors, for example, hosting providers, and we use Azure and AWS for managing our data and other systems, and we have DPAs with both these companies. Go ahead, Viv.
The third item the GDPR mandates is the nomination of what's called a data protection officer for each company. This person does not have to be a data expert, but they need to be legally responsible for the data flow. Typically, they're employees like the CEO or the COO or the general counsel, depending upon the size of the company. This is a key element that must be identified and named.
Yeah, and the final requirement that matters, and I'll talk about that a little later too in detail, is that consumers need to have the ability to look at the data which has been collected on their behalf, as well as the ability to delete or to be forgotten. This is a tough technical challenge, and this is needed in order to be compliant with GDPR. Okay, I'll go straight into the ethos of GDPR. And before I go deep into this, I want to give a little bit of history. So if you look back at the whole landscape in terms of information technology, go back like 20 to 25 years, and if you look at corporations which have managed information, they have been treating this, or they have been treating information as assets. And if you go back, all the way to the 95s, you have this concept of a CIO, which has become pretty prominent. And managing assets, more like digital assets, have been important for job creations and in terms of revenue generation for companies. And part of this is information security, right? So when you look at assets for revenue generation, one of the key pieces of these assets is consumer data. And consumer data is used to personalize the experience of the corporations and also to accelerate revenue. But what we have been seeing in the last little while is the shift of power in terms of managing data going back to consumers. And before, since organizations have been wielding a lot of this power shift has been happening in the last decade, and GDPR is one such initiative. And I look at this cartoon over here, consumers are getting more power. They're asking, why do I need to give you data before you start using it?
It's the data economy.
Okay, GDPR, again, what is it? It's a new regulation within EU, legislation intended to standardize data regulation across Europe. So if you touch EU citizens, you will be, you will have an impact. Who does it affect? Again, like I said, companies who have operations in the EU, customers and users in EU. So if any of your respondents, if I talk survey landscape, any of your respondents are EU citizens, this affects you. 4 things to keep in mind. Okay, number 1, the date itself, 25th May 2018, a hard stop. So you have to get ready, and there are not just the solutions you use, not the SaaS vendors you use, the whole process around managing data, who's responsible for the data flow within your company, at least starting to document what is going inside and outside your company. It does replace the former data protection directive. It also has privacy protection for EU citizens around their personal data. Like Vivek mentioned earlier, it has steep fines for non-compliance, which is ratio around your revenue itself. Okay, how are you affected? If you're a consumer, you are in the driver's seat, good for you. If you're not, if you're an organization who's dealing with EU type data, you have to go ahead and appoint a data protection officer. And again, last but not least, penalties around not complying.
All right, so we've kind of understood, to some extent at least, we've kind of understood, like, it's a set of regulations that's coming in. And like I said earlier on, there are 4 things that we want to talk about today that we think are relevant, pertinent, important, and we need to think through this. And what I'm going to do is, over the next 15, 20 minutes, walk you guys through each of those 4 elements of informed consent, data DPA agreements, data protection officer, and kind of consumer right to access and be forgotten, which is kind of a complex kind of use case, if you will. So let's go into, before we jump in, kind of from a kind of data collection survey perspective and research survey, if you're doing, consumer insights as well as collecting data from even customers for that matter, the respondent journey, from the way we look at it is, the administrator of a survey designs a survey, sets up certain settings, especially if they're accessing EU citizens or they themselves are in the EU zone effectively. The primary thing that they need to do is to select a data protection officer internally, deploy the survey, collect the data, and then make sure when the respondents are, giving input, giving data, they understand their rights, they understand their, what is going to be done with the data and whether it's going to be sold. It's actually not illegal to sell people's data. You just have to let them know that, once you collect the data, you intend to sell the data for that matter. So one of the things that, GDPR does is it doesn't really say what you can do with or you cannot do with the data. What it does tell you is in terms of getting informed consent is a pretty important element of the articles that have been published for GDPR. And then the respondent needs to have the right to be forgotten, which is, clearing out the cookies, clearing out any data that he may have given you, and we'll walk you guys through a workflow that we've kind of, envisioned to enable our customers to comply with that particular element of it. And then, as you can see through the journey, if in case a respondent requests the right to be forgotten, then we have certain systems in play that help you go through that process.
Just before you go, Vivek, we have a question coming in from Jenny in Florida. She is a market research consultant. And the question is, when a user requests a delete, how does it actually work and who is responsible for that?
Good question. So the right to be forgotten is obviously part and parcel of the GDPR directive. And when a user requests, a delete from, to QuestionPro through a survey, we do two things. One, we remove all the cookies that we've placed on the cookies browser throughout, from a technical perspective. And number two, for the data that we've already collected on behalf of that user, we send out a workflow request to the administrator of the survey so that they can either approve or disapprove that request and go through the deletion process of the underlying data that we've collected on behalf of our customers, which is, and then, from our systems altogether. And I'll walk you guys through a workflow process as we go through this.
Got it. And Jenny just types in, does make sense so far.
Okay.
Just pausing for a second here to see if any more questions have come up.
All right, so Anup, why don't you take a look at the questions? I'm going to keep going. So let me walk into informed consent, right? So the first thing that we want to kind of do is, as users are taking the survey, we intend to put for the surveys that are GDPR compliant, we intend to put a special link that describes privacy and data security as the users are taking the survey. It's a permanent footer that the users can click anytime and go into a screen that gives them more details about the privacy statement, about the use of data. As you can see in the screenshots, what we've done is kind of distill this down to 4 different components of your privacy policy that has to be explained in relatively simple English or very simple language probably, and we think that this will, explaining how you're using the data, are you selling the data, how can you contact individuals, and what is your data retention policy. So if you can explain these things clearly to the end users, and the same day, same information will be displayed to respondents when they click on the privacy and data security link. We believe that you will qualify as well as comply with the informed consent statute. Part of the things what we do over here is obviously support for multiple languages. So, if users are coming in and taking the survey in German, then obviously the informed consent has to be in German, so on and so forth.
Got it. That makes total sense. There's a question which has come up again from Ben. And his question is this a standard template? And Ben is an information security architect, and he's asking if he can customize this template for your company.
Absolutely. So what we've done is we've come up with a standard language that we think kind of applies to most of our customers. But obviously, as you can see, that it's an editable content. So we will give you default language that you can use. Clearly, it's your kind of privacy policy. It's not QuestionPro's privacy policy. How we are a conduit in this process. We are collecting the data on behalf of our customers at the end of the day. So if your objective is to collect the data and sell the data, then that's your objective. That's it. So we're not going to stop you or prevent you from doing that.
Ben still has a further on question around, is there a minimal language I should be using based on GDPR, or should
I think that's what we are kind of hitting up and say, like, at a minimum, you need to talk about data retention, use of data, sale of data, and contact individuals, right? So I think that's what we believe, that these are the minimum components that need to be addressed if you want to have like an honest, informed consent policy. Now let's talk about data protection agreement with vendors. So these are chain agreements that effectively chain all the users in a data flow model, right? And Anup mentioned that about earlier on. Like, for example, we currently have DPA agreements with all our vendors. Every system, every company has multiple vendors that enable a system to work. And our vendors are hosting providers, for example, right? So we rely on a couple of hosting providers as well as cloud-based services like Amazon and Azure to operate our services. And so what we've done is, obviously, we've gone out and had data protection agreements with both Azure and AWS. And what this logically means is that our customers would need data protection agreements with us effectively. So if you are a QuestionPro customer, what we've done is, when you enable GDPR compliance, we automatically generate a DPA agreement for you. That's a standard boilerplate agreement that we have, and it's pretty much, frankly, the same agreement that we've run with our vendors. So that's kind of, it's almost a chain of responsibility, and largely what the agreement states is, like, we all know there are 99 articles. We all are going to follow the same sort of guidelines and rules, and we are all kind of bound by the same set of principles and operating principles effectively. So what the agreement really does is puts a legal framework around our need for operating under that framework effectively. So on a very practical level, what does that mean? On a practical level, customers, when they turn on GDPR compliance within your account in QuestionPro, an automatic agreement is generated for you, and you can use that agreement as the legal basis as the legal basis itself.
Got it. Just hang on a little bit there.
Okay.
So we have Melanie, who is our existing customer. She says she's a small market research firm with just 3 researchers. And she's asking, do we need to have DPAs in place because we only have you as a vendor and other vendor who we deal with on an accounting basis? Do we need a DPA in place?
I would say yes. I mean, I think the whole argument is it creates a chain of responsibility. So if, I would say, like, whether you're small or large probably doesn't really matter. If you are, as a market research vendor, if you are collecting data on behalf of your customer, then very likely your customer would want a DPA from you. Okay. And then if you are using, a technology platform like QuestionPro to collect the data, then you would need a DPA with us. Then we rely on Azure and AWS for actual physical hosting providers. We need a DPA from them. So in that way, the chain of command is clearly documented. And so going back to the question, yes, even it doesn't really matter if you're a small company or a big company. Anybody who's handling data on behalf of their customers needs a DPA agreement. At least that's what my understanding is. The next part I want to talk about is the data protection officer itself, right? And this has come under some kind of, a lot of people have asked me questions like, does every company need to appoint a DPA, a DPO rather, a data protection officer? And it's actually yes. And what we do is, within the system, you can set up anybody within your organization as a data protection officer, and we display that information to the end users, to the respondents, when they click on privacy and data security. So this gives every company the ability to kind of say who their data protection officer is, their contact information in case of a dispute, who do they go to, who do they talk to, frankly. It's a fairly straightforward kind of, at least technically this is pretty straightforward, but operationally, our recommendation is you have to think about who do you appoint as the data protection officer, because that person is effectively, legally responsible for the data that is flowing through the system.
Got it. Ben has a question. Same Ben.
Okay.
Can I have an external resource as a DPO?
Yeah, I mean, I think there is nothing in the regulation that states that data protection officers have to be internal employees or consultants, or not, for that matter. It's just like, the key element within the regulation is that they need to be able to affect change. They need to be able to be responsible for the data that's going through the system. So whether it's an outsourced legal counsel or whether it's an outsourced CISO. I know a bunch of companies that have outsourced chief information security officers. They could double up as data protection officers because they have a pretty good understanding of the data flow within an organization and what protections and what systems have been put in play. So going back to the question, so there is no legal requirement for the data protection officer to be physically a full-time employee or not, for that matter. It's just that the data protection officer must have access to the data flow that is going through the system, must have access to, must be in a position to make changes and report out changes. And that's kind of one of the key components over here, is that it's assumed that the data protection officer's responsibility is to notify all users affected within 72 hours of any breach. So in that, in our case, for example, if QuestionPro ever got breached, it will be our responsibility to notify all customers within 72 hours that QuestionPro got breached. Same thing. Same argument applies to Amazon Web Services. They have a DPO who's responsible to notify us if there's a breach within AWS. And same, I think, again, the chain of command applies across the board the same way. And that's why the system is set up in a way where, there is a chain of command. So everybody is legally responsible with the same set of rules, right? So if Amazon has to notify me within 74 hours, and then I'll turn around and notify all the DPOs that are registered with us within 72 hours. So the same rules apply.
Got it.
So, and finally, let's talk about the right to access data and be forgotten, right? So, and one of the things that GDPR does is protection by design. So what that means is, part of the regulations require us to be respondents and end users to be in control. As Anup said earlier on, one of the paradigm shifts that's happening is that the data itself, the digital exhaust that people are providing, our respondents themselves and consumers themselves are in control of that digital exhaust and data that is being provided. So what we do is, once GDPR compliance is turned on, we allow users to actually download their data either in a PDF format or kind of machine readable JSON format, as you can see on the screen. This allows, and this is based on cookies and all those users and all the data that we've collected from that user, and we have a timestamp of when and obviously we store everything as to when that user completed which survey, and we can display a list of all the surveys that they have completed, and they can download a PDF copy of the response, and obviously a machine readable JSON format copy of the data itself. And as you can see, there's a delete button also over there, right? So the delete button allows you to kind of fulfills the kind of right to be forgotten model, where once you hit the delete button, like I said earlier on, the question was asked, like, what happens when you hit the delete button? What happens when somebody says, like, look, you know what, I've given you some data, but I actually don't want to do that anymore. I want you to erase everything that I've given to you I've just given you, really. So what do you do then, right? So what we are envisioning over here is there are two components to it. One is a set of cookies that we place on the respondents' browsers about just to track them as to what they've done and what they've not done. So we will remove all those cookies if a request is received automatically. So the browser cookies are cleared automatically. However, the data that we have collected, clearly we don't own the data. It's owned by our customers. That is you, typically. So what we have is a workflow system that would then trigger an email to you saying that a respondent has requested a deletion for a particular response. And an email will get triggered. We won't actually remove the data from our systems, clearly because we don't own it yet. And what we are providing to our customers is a workflow system that enables you to easily, be compliant over there. So you would get the administrator would get an email request, and then the administrator has a view of all the requests that have been submitted for his account. And then they can either approve it or deny it. And we don't want to get into the middle of whether you're approving it or deny it. What we want to do is to provide you the mechanism to do it, make it easy for everybody. And then if you choose to approve, it, then the data goes away from the database and from our backup systems and everything else. And it's permanently deleted from our systems. If you choose to not approve it, then the data stays. And I don't think we have a position in terms of what happens if you choose not to approve it. That's something between the respondent and you. We are just a technology provider, and we don't want to get in between them.
Got it. There's a question coming from Mohammed, who is heading up a CSAT practice within a retail chain with EU customers. Mm-hmm. His question is, how quickly, I guess you already answered it and it's coming back again, is how quickly should QuestionPro delete the data?
So yeah, I think that in terms of the right to be forgotten, I think, like I said earlier on, we are going to immediately honor the request vis-a-vis cookies, which is a fairly straightforward thing to do. We store a bunch of stuff, technical, footprints, if you will, on the browser. We go ahead and remove them. But then the data that we have collected that's stored in our databases, we don't go out and remove them. It's not, technically, I would argue that's not our data for us to remove automatically. But what we have done is obviously provided you with a workflow that allows you to kind of, just approve or deny each of those requests as they come through. Our anticipation is, this is going to be, few and far between in terms of when people are asking for, the right to be forgotten. And when they do ask for it, you have to take it seriously. As in somebody says like, yes, I gave you this data, but I don't want you to have it anymore. And that would be kind of fundamentally kind of not our position to say what is approved and what is not approved. Like I said, we are a tech company. We are not the enforcers of this system. We are enablers of the GDPR regime, if you will.
Got it. Another question from Mike from Germany. So EU is going to have this harmonized set of rules and data, and obviously more control and protection for consumers. What if I run a survey sitting in EU, and the survey takers are American citizens, and also did not collect data on race, health, or any political opinion? Do I still have to comply?
Yeah, if you are in the EU, it's pretty simple actually. If you are in the EU, you must comply. If you are based out of the European Union, you must comply. If you're collecting data from European citizens, you must comply. It's actually as simple as it gets, really. So if you're based out of any country in the European Union, then clearly you're domiciled in the European Union, which means you must comply. If you're an American company that is collecting data from European citizen, then also you must comply. So in general, our position on this, it's a fairly sweeping kind of, if you think of it, that was the bigger problem with jurisdiction with the other older European regulations. Like nobody really understood what the jurisdiction was. And what GDPR has done, frankly, is clear the air with respect to jurisdiction. Like who does it affect? Is it affect everybody? I would say it affects all transnational companies. Clearly, most companies have some, some customers in Europe, and it has, if you know that you have customers in Europe, then you will be affected. And clearly, companies in Europe are affected. There's no doubt about that. That they're domiciled in that country, in any one of the European Union nations, and they have to comply. And we can talk about a lot more with respect to GDPR, but we wanted to keep this thing really tight and short so that we can really kind of focus in on what we believe are the most important elements. Like with every regulation, like I said earlier on, that there are you can literally read 200 pages. There are 99 articles, each with 3 or 4 pages effectively. And yes, there are a lot more to GDPR than these 4 things that we are talking about. However, it's our opinion that these 4 things are probably one of the, a few of the most important items for compliance with GDPR. And with that, I think we came to the end of this short session. So
right. Some questions are trickling in, but most of them seems to be overlapping with what came before. So just to keep this thing a little more efficient and save all of you a lot of time so we can give you back that time, what we're going to do is collect all these questions.
And we put together a FAQ. I mean, how about we'll put a FAQ together and publish it on our blog and send out an email to everybody. We'll also send you guys this deck over email. All the folks who registered will send the deck, as well as the recording of this webinar also will be sent out to you guys. So so if you want to forward this off to other folks within your company, feel free to do that. Yeah, I mean, we're going to compile all the questions and put a kind of more kind of digestible FAQ together that is more relevant, and we'll send that email out in a day or two.
That makes sense.
Thank you, guys.